Hello everyone, this is part one tutorial for property offences, and in this recording I'm going to be covering the offence of theft. So I want to start off with seeing if you can identify the correct definition of theft. So if you want to pause and have a read through A to E definitions and then see if you can circle which one you believe is correct. And hopefully you've identified that the correct definition is under D. So a person is guilty of theft if he dishonestly appropriates property belonging to another with the intention of permanently depriving the other of it. Now you need to know this definition off by heart, and I would say the best thing to do would be to keep repeating it, and that's what I would be doing if we were in the classroom right now. So what we're going to do is identify the elements of this definition going forward. We're going to look at the relevant legislation and case law, and then later you're going to apply and evaluate this area too in the same way that we do with the other areas. So what has to be proven for theft? So we have the Theft Act 1968, and theft is covered under sections 1 to 6. Now section 1 is just a generic section which says that any person charged with theft will be charged with stealing contrary to the Theft Act. So it's a charging section, if you like, so not one that you need to ever write about. The relevant sections that you would need in an exam would be sections 2 to 6, and they run in order according to the definition. So if you write the sections next to each of the elements below, so dishonesty or acting dishonestly would be section 2, appropriates would be section 3, property section 4, belonging to another section 5, and having the intention to permanently deprive the other of it would be section 6. So I want you again to pause this and see if you can identify which of these elements cover the actus reus and which cover the mens rea. And hopefully you've identified that the appropriating of property belonging to another, so those three middle elements, are the actus reus, the guilty act, the physical element of the crime or elements. And acting dishonestly and having the intention to permanently deprive the other are the mens rea elements. So there are 3 actus reus elements and 2 mens rea elements here. As is the case with any criminal offence, all have to be satisfied for somebody to be guilty of a crime. So start off by looking at dishonesty. Now, although I've just taken you through the legislation, dishonesty is slightly different in that section 2 does not define this element. Section 2, as you'll see on the next slide in your booklet, actually covers exceptions, or we could say defences to where somebody would be deemed to be dishonest. So quite interesting actually. The rest of the sections aren't like that, you'll be pleased to know, but I'm going to talk you through what dishonesty means, and there has been some big changes over the last few years that we need to talk about, and these changes have come from this case here, Ivy v Genting casinos, and that was 2017, decided in the Supreme Court. So initially, the definition or the meaning of dishonesty was set out in an old case. So this was common law. And in fact, after the legislation was passed, which indicates obviously judges felt that Parliament didn't quite cover the meaning of dishonesty in section 2, which if you look at the legislation, they didn't. So the test for determining whether somebody was dishonest came from a case of gauche, and please have a look at the facts of gauche. It was to do with a doctor, a locum doctor who was charging for operations that he wasn't actually carrying out. So he was decided to be dishonest in that and therefore guilty of theft. And the test was 2 stages. So firstly, the test for the jury to decide, or for the magistrates if it was the magistrates' court theft case, was, did the defendant believe that his conduct was dishonest? If the jury or magistrates answered yes to that question, then they could move on to the second question, which was, by those standards, would a reasonable person also view his conduct as dishonest? So what we had was a subjective test in what the defendant believed themselves, and then an objective test, which was judging the defendant according to the standards of the ordinary reasonable person. And just remember, when I'm referring to he or his, we can use the Interpretation Act 1978 to deem he to include she and others. So just remember that. We're not just talking about one here. So we have a subjective and objective test here for theft, and this is how the law of theft has been applied since 1982 right up until 2017. The problem with the old test was that, of course, looking at number 1, first and foremost, if a defendant didn't believe their conduct was dishonest, if they didn't know, or the jury or magistrates believed that they didn't realise that they were being dishonest, then they had a get out of jail free card, if you like. They couldn't be convicted of theft. And actually, it was and has been, even up until I was in practice, very much was the main element that defendants would be able to rely upon to be acquitted. So there was a bit of an issue here in that subjective element, and this has been addressed now in the case of Ivy and Genting casinos. So I'll just explain to you what happened. First of all, what I'll say, which is seen as a criticism, is that this is or was a civil case, so not a criminal case. Yet the Supreme Court appear to have formed a new dishonesty test which covers and could be used in both civil and criminal proceedings, which is quite interesting. So the facts involve a professional poker player, Phil Ivey, who was playing at Genting casinos one day. He was a regular poker player there, so he was known by the staff. He won £7.7 million, and the casino had actually refused to pay this to him because they alleged that he was cheating. Now, I don't know a lot about poker, and you can read up on this case in more detail online, but it used a technique referred to as edge sorting. So he was basically able to identify differences, unintentional differences on the cards, and kind of manipulate the cards that he chose from there. And apparently he was being kind of humoured because he was known, but when it came to winning a lot of money, the casino refused to pay it out. So this was a contractual dispute, hence why I say it was a civil case, because the claim was that he had breached an implied term between him and the casino. An implied term in any contract is basically one which isn't written or expressed. It is expected to be included by nature of the agreement. And the implied term here was that he shouldn't cheat. As a customer at the casino, or as a player, as a member, the expectation is that he shouldn't cheat, and that isn't one that necessarily should need to be included in a contract, written, if you like. So the High Court of First Instance, and actually the Court of Appeal on first appeal round, found that he was cheating. And they found this due to obviously applying the bog standard ghost test. But when Ivy appealed up to the Supreme Court for this to be decided, obviously all hinging on whether he was dishonest or not, the Supreme Court expressed concerns with the ghost test. What they said was that the subjective part, in terms of whether the defendant themselves believed that they were acting dishonestly, he said that required the defendant to conform less with society standards and enabled a get-out. They said the law shouldn't excuse those who make a mistake about contemporary standards of honesty, and the purpose of the law is to set acceptable standards of behaviour. So they decided to form, if you like, the new test, where they effectively removed the subjective element. And if you see what is in bold in the middle of your screen, by the standards of ordinary and decent people, would the conduct be seen as dishonest? Okay, so the main focus is going to be on the objective standards. The outcome for Ivy was that he was still deemed to be dishonest, so he never received his money. And the effect of that case now is that ultimately, because it's seen to also be used in criminal cases, although arguably there was no comment by the Supreme Court to say it would be binding, but the effect is that defendants may now struggle to avoid criminal liability based on their own perception of dishonesty. And actually it does bring the mens rea a bit more into line with other criminal offences. As I say, and I've seen in practice as well, too many defendants were able to use the subjective test to their own advantage there. But of course the problem with this would be that we're not actually taking into account the defendant's views as much as we did, and therefore some people may be unjustly convicted. So that is the test for dishonesty. Section 2 of the Theft Act 1968 kicks in, is where a defendant may almost be able to raise a defence to being dishonest. There may be a reason that they can use to say that they haven't acted dishonest, and there are 3 under Section 2. And these in the legislation are seen as Section 21A, 21B and 21C. So firstly, 21A, they believe they have the right to deprive the other of it on behalf of themselves or a third person, or they believe they would have had the other's consent if they had known of the appropriation and the circumstances of it. Or finally, they believe that the person who the property belongs to cannot be discovered. In other words, it's abandoned property. And there is a case, authority to evidence Section 21C, where Small took a car that he thought had been abandoned, and he was charged with theft. On the facts, the car had been left in the same place for 2 weeks with its doors unlocked and the keys in the ignition. It had a flat battery, no petrol and a flat tyre. And you think, well, is it reasonable that somebody might believe that car was abandoned given the state it was left in? He claimed he took reasonable steps to find the owner, and he was actually successful, and the court here said even if that belief is unreasonable, you may still be able to rely on this exception and indeed the other exceptions. So don't forget to have a look out for, you may find somebody dishonest, but could they potentially rely on one of the exceptions to, if you like, negate that dishonesty? So some of the problems with dishonesty, it's been in the past notoriously hard to prove because, of course, for the subjective part in gauche, we're having to go almost jump into the defendant's mind and identify whether they understood that they were being dishonest. Now, if they're telling you as a jury member or a magistrate that they didn't realise they were being dishonest, it's going to be very difficult to satisfy that element, and therefore you're not going to be moving on to the objective stage, and therefore you're going to be finding them not guilty. So for the prosecution, for years and years, this was a really difficult hurdle or obstacle to overcome. And as we'll see, when we look at the actus reus elements, they are very wide, easier to prove, if you like, almost intentionally. certainly through case law. So actually a lot of cases did hinge on whether dishonesty could be made out or not, which again resulted in fewer convictions. But of course the update with Ivy, you could say, makes the test fairer, but since it derives from a civil matter, there is some uncertainty on the effect on future cases. I mean, it's been decided in the Supreme Court, so we could argue it is going to be binding. So just having a look at some application, we will go through these in later tutorials, but just make sure that you can identify whether somebody's being dishonest. So pause here, please, and have a go at these short scenarios. So in terms of Roland, we would be applying the Ivy test. By the standards of ordinary and decent people, would Roland's actions be deemed to be dishonest? I mean, he's found money in a very small workroom in a factory. He decides to keep it. It's likely that objectively he would be deemed to be dishonest. He could raise Section 21C. Maybe he believes the property has been abandoned. Given the number of employees, the small factory, the nature of the employment is probably unlikely to be successful, so therefore he would be deemed to be dishonest. Venus, taking clothes free of charge outside of a shop, objectively she is likely to be seen as dishonest, but she might be able to raise sections 21A or 21B. Maybe she believes she has the right to deprive the owner based on what her background is, and maybe she believes she would have the consent. So she may be successful because these exceptions are subjective. You know, they're based on what the defendant believed at the time. Less likely for Roland to be successful given that he only works with 20 people, but for Venus, she may actually have more chance of success here by raising sections 21A or 21B. We move on to appropriation, the first actus reus element, defined in section 3. Appropriation means effectively assuming the rights of the owner. So most commonly this could include taking property. If you take something from somebody where you aren't the owner, you are assuming the right of the owner. But this is so wide. This could extend to touching somebody's property, using it even temporarily, borrowing it. Anything you do with an item of property could be deemed to be appropriation. This includes if you come by the property innocently or not, so you don't have to have the mens rea, if you like. Appropriation is an actus reus element. Maybe you find the property later and then decide to keep it. So we're going to look at all of these particular. Now, assuming the rights of the owner is really wide, and the case of Morris, which is the leading case here, says that a defendant can assume any of the rights of the owner. They don't have to assume all of what an owner would do with their property. So they only have to do one thing, if you like. So Morris was in a supermarket, switched the price labels of 2 items on the shelf, placed the lower priced item in the basket and went to the checkout. This was considered to be an appropriation. He was assuming the rights of the supermarket owners when he switched the price labels, and hopefully you agree that's not something that we should be doing unless we own those goods as a supermarket. The House of Lords, as it was then, said it is enough for the prosecution if they have proved the assumption of any rights of the owner of the goods in question. But of course the problem with this decision is that if any right of the owner could be assumed, then we are always going to make out appropriation, aren't we? It's really wide. And in the later case of which had slightly different facts. So Gomez, being an employee, authorised stolen cheques at work so that he could steal money. His employer did sign them off, but was unaware, of course, that they were stolen. But the House of Lords kind of took the opportunity in this case on appeal to discuss the extent of which assuming the rights of the owner could kind of go. And they talked about whether, looking at the supermarket instance scenario in Morris, if you are deemed to be assuming the rights of the supermarket by switching labels, do you also assume the rights where you take goods from a shelf and put them into your trolley? Now, one of the Lords said, no, you don't, because common sense would tell you, well, if you go into the shop as a shopper, then you have permission to take the goods from a shelf and you're not technically assuming the rights of the owner. You are simply being a shopper. So that's helpful, because there were some feelings that appropriation would end up being really wide. And Gomez, the House of Lords in Gomez, took the opportunity to confirm that theft will only be committed if all elements are present. So, of course, whilst you might assume the rights of the owner in touching an item or using an item or changing it in some way, you're not going to be guilty of theft unless the mens rea is present too. Okay, we've got some more cases which illustrate how wide appropriation can be. Appropriation can occur even with a victim's consent. And the leading case here is Lawrence against Metropolitan Police Commissioner. So this case concerned an Italian man who spoke very little English. He took a taxi in London, gave the taxi driver an address on a piece of paper. At the end of the journey, he had his wallet open and gave the taxi driver an amount of money, which should have been enough and was deemed on the facts to be enough, but the taxi driver intimated it wasn't enough and proceeded to take more money out of his wallet. The taxi driver was convicted of theft, appealed, and claimed that the victim, being the Italian man, consented, so there was no theft here. But the court disagreed and upheld his conviction and said, you did appropriate the money, even though it appeared that the victim was consenting. Appropriation still occurred, and therefore the theft is upheld. And if you go back to where we've been looking at the general principles of consent in our previous topic, the consent here certainly, if that argument was to be considered, the consent wasn't real, it wasn't informed, was it? And it was arguably fraudulent, so he was never going to be successful on that argument. But of course, appropriation still occurred here nonetheless. The case of Pitham and Hell, in this case, the defendant sold furniture belonging to a friend who was in prison. And this defendant, selling the property belonging to his friend, actually wasn't able to sell any. But what the court said was that the offering of selling property was enough to be an appropriation. So even if any hadn't been sold, this was still an appropriation here. So it shows you kind of how wide you can assume the rights of the owner by offering to sell the victim's property. And another kind of final example I want to give you to illustrate the wideness, even making a valid gift to somebody could be held to be an appropriation in law. This comes from the case of Hinks. So Hinks was the defendant, a 38-year-old woman who befriended a very naive man with a low IQ. So he had learning difficulties. So they were good friends over a period of 8 months, and on a number of occasions the defendant accompanied the man to his bank where he deposited money into her account. Ended up being £60,000 in total. So when questioned by police, she argued that it was consensual and therefore she wasn't guilty of theft. It's actually important to note that in civil law, this would be recognised as a gift and a valid transaction. But obviously this was a criminal case of theft, went all the way up to the House of Lords, and she was actually all the way up through the appeal courts deemed to have been appropriating and therefore guilty of theft, despite this being a valid gift. The House of Lords actually recognised that on several occasions these were valid gifts and consent was given, but they actually said consent was irrelevant here, particularly in relation to appropriation. She had appropriated, she had assumed the rights of him as the owner. Of course, consent is relevant to mens rea under section 2(1)b, but the issue here, the point in contention, was on appropriation. So I suppose it's a bit of a criticism, really, looking at the relationship between the actus reus and mens rea. They can conflict. If we're saying consent is irrelevant in relation to the appropriation, so the actus reus, yet consent is relevant in relation to mens rea, the two don't match up, do they, and make sense, really. So what happens if you are deemed to be what we call an innocent purchaser of property that is stolen? Are you appropriating, or does the law protect you? Now let's just go back to what appropriation says under section 3, subsection 1, so the definition. So it obviously mentions that you appropriate if you assume the rights of the owner, but it also says that an appropriation can occur at a later point, where the defendant acquires property without stealing, but then decides to keep the property and deal with it as the owner. So an appropriation can occur later on, when they realise, if you like. But Section 3, importantly, does say that if you buy the property in good faith, you don't commit theft when you subsequently learn that you are not the owner. So if you buy it in good faith, you are protected as a purchaser. If you come across the property in another way, you may not be. That's the crux of it. And the reason why is because you are deemed to be the proprietary owner. And therefore you can't be alleged to have assumed any rights. If you buy something, you become, in law, the proprietary owner of that piece of property. And that's why you are protected. But if you come across the property in any other way, you may not be. And the case of Adams is a good illustration of this. A motorcycle enthusiast who bought parts for cash, given a receipt, understood they'd come from a write-off but didn't know that they had been stolen. A few days later realised perhaps they had been. He was not going to be guilty of theft. He hadn't appropriated the property, he had bought it in good faith, and therefore he was protected. Just keep a lookout for that. So some scenarios, so if you want to pause and have a go, there are 4 scenarios. And then I'll take you through them briefly. So the relevant law here, for John, he would be deemed to have appropriated using the authority of Pitham and Hell. He's holding an auction of his neighbour's tools. Doesn't matter that he hasn't been able to sell any of them. Now Saskia, her son takes a bar of chocolate. She doesn't realise till she gets home. Now, she's not protected in the same way as Adams was by the legislation, because she hasn't purchased the property in good faith. She has assumed the rights of the owner, i.e. the shop, she has a later assumption, so she's acquired the property without stealing it initially. Obviously her son, who is too young to be prosecuted, has taken the chocolate bar, but when she decides to keep it, that's the point at which she appropriates. So she could potentially be academically or practically liable. Number 3, we have a case of appropriation. So Roger is assuming the rights of the owner. He's not doing what he's been asked, and this will be linked to another element we'll see later. And number 4, the case of Hinks would be relevant here. This would be an appropriation, certainly. Okay, so appropriation of property, we have to make sure that what's being stolen is actually property. So property under section 4 includes money, personal property, so things that belong to the victim, personal items. Real property is a legal term for land and buildings, although see below, land generally won't be included unless say you're a trustee of property, so somebody's died and you're dealing with their property in accordance with what they've set out they want to happen with it in their will. Let's say you do something that is against their legal wishes, then that would potentially be theft. Or if you dig up something or remove something that is part of the land without permission, and that's where you might be liable here, and that would come under real property. Things in action are kind of bank related, so it could be a cheque or a transfer. Intangible property, things that can't be touched, so could be stealing a brand or the rights to something, but this could also come under a civil area of law called intellectual property. If you steal the copyright to something or the trademark or logo, you start trading under somebody's logo or branding, then you're more likely to be sued than to be arrested by the police. So it really depends on what the nature of the matter is there. Do look up Oxford and Moss, really interesting case and has featured on exam questions before. A university student who copied an exam paper. They were charged with theft and held actually to be not guilty. And the court said here, information cannot be stolen for the purposes of theft. So you could add information under your not parts of property here. Had they stolen the actual exam paper, that would have been different. So in addition to what isn't considered property, you see here wildflowers and mushrooms. So picking wildflowers or mushrooms out and about wouldn't be property unless you sell them for commercial purposes. Wild creatures, but of course with any of these it depends, well, where are they kept, in what domain, whose land are they on. Electricity can't be stolen, but there is an additional section under the Theft Act, section 13, where you could be guilty of diverting or wasting electricity without authority. So that kind of covers that anyway. So from that slide, which one of these is property? If you want to pause and just have a go at those. So hopefully you've identified that number 1 would be theft. Number 2, A, wouldn't be theft, but B would be theft, or should I say would be property. 3, property. 4, A and B, not property, using Oxford and Moss. Number 5 would be property. Okay, property doesn't really pose many problems apart from Oxford and Moss, excluding certain circumstances. Belonging to another, really important element, again still actus reus. What does the legislation say? Property belongs to another if they have possession or control of it, or they are the proprietary owner. So this is quite wide ranging. So you don't just have to be the proprietary owner of something. The property can belong to you if you have possession or control of it. And that could be, for a temporary period of time. So see my example, a hire car, if stolen, we would potentially have two owners. The hirer would be the person who had possession or control of it at the time. The hire company would have the proprietary interest in it because it owns the car. So let's say you hire a car abroad or somewhere and somebody steals that from you, you could be deemed to be the owner because you were in possession and control. You were hiring that car at the time. So there could be two potential owners, and it's wide ranging really. For policy reasons, the CPS don't want to have to try and prove who the legal owner is where necessary. And you could have a look at a case called Dyke and Munro to see why, because there can be problems if the CPS charge the wrong people as the owners. They could actually miss out on prosecution there. So given wide, there have been a few controversial cases. The case of Turner being one of those, really famous case in the 70s because Turner was accused of stealing his own property, his own car, and made the papers, and he was actually found guilty. So he took his car into a garage for repairs. When he went to pick it up, he saw that it was outside with the keys in it. So he took it without paying. Now, when he was arrested and charged with theft, he obviously argued, well, I can't steal my own car. The car belonged to me, so I'm not guilty. But the court actually said, well, you did steal because the garage were or was in possession and control of the car at the time. So this kind of kicked in and he was found responsible. But what about if the property doesn't appear to have had an owner? So we know that if the owner can't be discovered, this can provide you with a potential defence to being dishonest. But can you have been deemed to have appropriated property belonging to another if that property is abandoned? So if genuinely and honestly abandoned, if the court believed that, then it can't be theft. But rubbish disposed of could be theft still, particularly in council bins, because once you've put rubbish into a council bin, if that bin isn't on your property, that's going to be property of the council. So really it depends on where that property's been abandoned and who has control or authority over that area. I remember representing a client a long time ago who used to like to steal property out of hardware shop bins. Now they were actually charged with theft. The case didn't go to court, but technically could be guilty because even though that rubbish has been discarded in the bins, it's still property of those shops. So just keep an eye out for that. Okay, got two subsections under section 5 that I want to take you through. These subsections have been put into the legislation to prevent loopholes. So prevent the defendant from escaping liability when they have possession of an item. So you could argue as a defendant, if you take an item of property, you could argue, well, I'm in possession and control of that property now, so I can't be guilty of theft. But there are two key things here, because you can come into possession of an item, but you may have an obligation to deal with that item or property in a particular way. And if you don't, you could be guilty of theft. And that's under section 5, subsection 3. So classic example you could see if this subsection wasn't here, where somebody might be able to get away with theft. So if you were given property by somebody and instructed to do something with it, then you could still be guilty of theft, even though you were technically the owner of that property at the time because you were in possession or control of it. Classic case, really good illustrative case, Davidge and Bunnett. So defendant was given cheques from her flatmates to pay for a gas bill, but she spent the money on Christmas presents instead. She could argue, obviously, dishonesty would be made out here, and as we'll see, intention to permanently deprive, but she could argue that she hadn't appropriated the property belonging to another because she was in possession or control at the time. She was the owner. And that's where section 5 subsection 3 kicks in. She had an obligation, a legal obligation, to deal with the property in a particular way. Section 5 subsection 4 works in the same way, and this is where you may have an obligation to restore property. So there is an obligation to restore and give back the property. If you fail to do so, and of course the other elements can be proven, then you'll be guilty. And really good example, AG's reference, so an Attorney General case here, number 1 in the year of 1983, and you see it concluded in 1985. The defendant was overpaid salary into her bank, and I wonder how many people have had an instance of that where they've received money that they perhaps shouldn't have. You can then argue, well, I'm the owner, I'm in possession and control of it, so therefore I can't be guilty of appropriating property belonging to another. And that's where this subsection kicks in. You have a legal obligation to restore the money if received wrongly. Okay? Have a look at these two scenarios here. Pause and just decide whether the property's been appropriated that belongs to another. And hopefully you've identified number 1 as being belonging to another using Turner. And number 2, hopefully you've identified Dorothy as having liability under section 5 subsection 3. She had an obligation to deal with the property in a particular way. Okay. Really well. Final section, intention to permanently deprive. This is about the intention. This is not an actus reus element, so you don't have to have permanently deprived somebody of property to be guilty. This is about having the intention to permanently deprive them. So this is about looking at a defendant's state of mind, and contrary to the dishonesty rules, this is subjective. We're looking at what the defendant believed at the time or what they intended at the time. Was it their main aim or purpose to permanently deprive the victim of the property? Key evidence the prosecution could use, of course, would be really basic, obvious: stealing food and eating it, stealing money and spending it, stealing an item and selling it. So if you received that additional salary in your bank and then you went on to spend it, that could be evidence of intending to permanently deprive your employer of that money. Of course, you could claim that you didn't know you had it, but that would be a question of fact, really, for the jury or magistrates to decide. A really important case here is the case of Vellamall. So the defendant was a company manager who took £1,000 from the office safe. He said he owed the money to a friend and was going to replace it. That classic line. Convicted of theft, they said he had the intention to permanently deprive the company of those particular notes, which kind of gets around the excuse of intending to replace. He was never going to replace with those exact notes. What happens if you borrow property or property's been lent to you? Usually, practically, borrowing won't be theft unless you've borrowed for so long that it amounts to an outright taking or disposal. And we have to look at the facts as to whether you believed you would have the permission, so section 2(1)(b) for dishonesty, or whether the victim agrees that they lent you that property. But let's say you borrowed something and then you give it back and it has less value, so you're not giving back the whole property. Is this going to be theft here? And this was decided in Lloyd, where Lloyd worked at a cinema. This was 1985, where we had sort of reels used in cinemas. He borrowed some cinema reels, took them home, copied them, and brought them back. Now, he was charged with theft, but actually he was not guilty in the end, because although he had borrowed the property, there was no value gone out of the property. They weren't damaged. He was able to return them in their original state. So the issue, of course, would have been the mens rea really there. But he certainly wasn't guilty of intending to permanently deprive. So you could liken it, and you'll see when you start applying. Let's say somebody borrows a football match season ticket from you, and they give it back at the end of the season. Well, they're giving it back with no value in that item. So if you argue that you hadn't given them permission, or you wouldn't have given them permission, then they could be guilty of theft. Just a final kind of point to consider, this point of conditional intent. Conditional intent is all about a defendant who decides to steal only on the condition that there is anything worth stealing, or that the items are there. So this covers kind of opportunistic thieves as well. So let's say you see a house with the window open and you think, I'm going to go in there and see if they've got a TV to steal, and then they haven't got a TV, so you leave. Are you still deemed to have the intention to steal? For the most part, of course, yes, you would. But there was an interesting case, Esom, in 1971, where the Court of Appeal decided that this wouldn't always be the case. So this was a defendant in a cinema who picked up a handbag of somebody and rummaged through the contents, but didn't find anything that they thought was worth taking. So they put the handbag back. The police were called and they were charged with theft and convicted, but it was actually quashed on appeal, because the Court of Appeal decided there was no evidence that they had intended to permanently deprive the owner of the bag or the items. They remarked conditional intent won't always suffice for theft. We have to have, or we have to be able to prove that there was intention to permanently deprive the owner, and this appears to be of specific items. So Easton was actually not guilty in the end. The issue we have here is it doesn't just make it vague, but contradicts other areas. If you think with the law of criminal attempts, you can be guilty of attempting the impossible. You could argue here Easton could be guilty of an attempted theft, attempting the impossible. There was nothing there that he was going to want to steal. But there you go, a bit of a contradiction. So, two final application scenarios. Pause please and just see if you can identify whether the defendant in either of these scenarios intended to permanently deprive. Okay, so hopefully you've identified for number one that Lloyd, the case of Lloyd, would be used here. So returning the season ticket with one match left, Andrew would be able to, we could say that Andrew intended to permanently deprive John of the season ticket here. Of course, he might be able to claim that he wasn't dishonest because he believes that John would consent. So 2.1b would contradict dishonesty here, but we could certainly evidence intent to permanently deprive. Having said that, with dishonesty not being made out, he wouldn't be guilty of theft overall. Remember, every single element has to be satisfied. The second one, hopefully you've identified a clear evidence of intention to permanently deprive here. So the bike is damaged, he doesn't return it, he throws it in the canal, he is clearly not intending to give that item back or replace it. Okay, so those are the elements, and what we will do later is have a look at more application, so you can have a go at applying the practice scenarios and make sure that you can use the law to establish each element. Remember, there are 5 elements, and you should, to make sure you get full marks, go through each one in turn. So was the defendant dishonest? Did they appropriate? Was it property? Did that property belong to another? Did they have intention to permanently deprive? And what you'll find in exam scenarios is there's usually 1 or 2 issues that are spotted and brought up, and you need to identify those to get the level 4 marks. Theft did come up as an exam question in 2019, so you'll have the opportunity to do that at some point and identify the key issues there. And I hope that you found that all useful. Thank you very much.